I'm Drew Stevenson, and this is a lecture for my Statutory Interpretation and Regulation class, or Leg-Reg, about the case Moskal versus United States. I apologize if I'm not pronouncing his name right. This is a U.S. Supreme Court case from 1990 that really exposes us or helps illustrate the problem of legal terms of art. Now, for my students, this is about a title washing scheme or ring. That's the crime at issue here. And we have a statute with a term that I actually think that the conspirators had planned to work around. So it would be hard to apply the statute to them. So we have a majority in this case wanting to apply what's the obvious congressional purpose, and then a dissent that wants to look at the common law use, how certain terms were used by common law courts and judges, which is a little different than legislative history or looking things up in dictionaries to say, how did courts in the generations before the enactment of the statute use a term? So that's why the case is really in your case book. And let's proceed. So this is going to talk to us about how courts sometimes read technical legal terms in light of how a word or phrase is understood in the legal community, and also whether a technical meaning of a term can carry more weight than contrary evidence of the legislature's actual purpose. So Moskal here, our defendant here, was part of a scheme, as I said, to roll back car odometers so that the car, if you were a buyer, would think it had lower miles and that it was in better condition than it actually was. And then one of the conspirators would actually alter the titles, basically forge a different number or change the numbers on a title certificate for used cars that were going to be sold in another state. And again, we call this a title washing ring. And Congress actually passed a law to try to address this very widespread problem. And hundreds of thousands of cars get title washed in the United States every year. The states involved in this case are still states where it's very problematic. So the statute says that a person is prohibited from knowingly transporting in interstate commerce, quote, falsely made, forged, altered, or counterfeited securities, which would apply to the car titles here and would apply to the mileage numbers that attestations that are on car titles. So again, we're talking about a title washing ring like you might hear about on your evening news. So Moskal's defense here was that he had not personally rolled back the odometers or entered the fraudulent numbers on the title form in Pennsylvania, where the ring was based. So they would get these used cars and somebody would roll back the odometers. Another person would fill in the new lower fake number on a title registration form or title transfer form and register it with Pennsylvania. And then they would ship the cars to Moskal in Virginia, and he would just take the new Pennsylvania title that was bearing the fake numbers from his co-conspirators and submit it for registration in Virginia. And so he was saying, look, I didn't actually do the forgery and I'm being charged under a forgery statute. By the way, I want you to think about, why did we get this? Why is the Congress addressing this? And part of the problem is, I want you to think about how hard it is for prosecutors in one state to prove all the elements for each conspirator for some of these interstate crimes, where you could have part of some of the elements intentionally being committed by your co-conspirator in another jurisdiction. And so it's hard to convict Moskal of forging the titles. And on the other hand, the person in Pennsylvania who's forging a title isn't selling the car to someone in Pennsylvania or defrauding someone in Pennsylvania. And so this is part of why a lot of these title washing schemes cross state lines and why there was political pressure for Congress to intervene on the federal level. So the court here holds that the titles were falsely made in the sense that they're made to contain false and incorrect information. And it determined that it said, come on, this is the very type of person Congress had in mind when they passed this statute. If it doesn't apply to Moskal, who does it apply to? And so they wanted a federal remedy against interstate fraudulent activities, which made fraud harder for any one state to detect and police. Now, Justice Scalia wrote a dissent with an unusual combination of justices joining him, like Justice Stevens. And he asserted that falsely made was a term of art, a legal term of art that refers only to forgeries at common law. And basically cites a lot of treatises and digests and legal commentaries from before the enactment of the statute. The majority answered that equating falsely made with literally forged was not a universal practice, even in the good old days at common law, and Congress's purpose and enactment controlled its interpretation. And if you read the opinion, a lot of it is consumed with just this technical debate. And I also hope you can see a little, maybe it won't strike you as ironic, that Justice Scalia, who would really blow a gasket when his fellow justices would dare to reference legislative history to find the meaning of a word in a statute, has no problem looking up old legal treatises and common law court opinions from the states to figure out what a new modern federal statute, what the term should mean. And so the problem here was that Moskal hadn't forged any documents, but he was definitely part of a conspiracy to submit documents that knowing that they contained phony information. Scalia argued in response to the majority that divergence from the common law position was the exception, not the rule. In fact, he says it's the exception that proves the rule and could not defeat a term of art interpretation supported by overwhelming evidence. And he said that the court's reliance on a broad purpose here was circular. Basically, that it's easy to say Congress's broad purpose was for Moskal to go to jail. And he thinks that that's sort of the ends justifies the means, or a circular reasoning. Where does this leave us? Okay, Congress's general purpose in enacting a law may prevail sometimes over a rule of statutory construction, so that where a federal criminal statute uses a common law term that maybe arguably had an established meaning without otherwise defining it, the term normally will be given its common law meaning. But again, what this is really saying is, if Congress's will is obviously clear otherwise, then we should go with that. Okay, here's a review question to see if you were paying attention. What was Moskal's main defense based on statutory interpretation? A, that he didn't forge any numbers or forms, but merely submitted the forms as he received them to the state registry, even though he knew that they contained fake numbers. Or B, that the statute didn't define vehicle, so it was not clear if odometers counted as their only parts of a car. Okay, that concludes our lecture about Moskal versus United States.